Hello friends, in the series on the income tax cases, today we will discuss a very important case. The name of the case is Jainam Exports versus Income Tax Officer. This case has been reported in 108 ITR Tribunal at page number 1. The matter has been decided by Honorable Surat ITAT SMC bench and the date of the judgment is 26th October 2023. This case is on the same lines where a number of the orders have been quashed by the various courts which have been passed in the name of the non-existent entity. For example, assessment done for a diseased assessee. The another example is when A company is amalgamated into B and the assessment is made in the name of A. Similarly, if a company is converted into LLP and the assessment is done in the name of the company who has been converted into LLP. In the present case, a different situation was there. The partnership firm was dissolved and it was duly intimated to the assessing officer at the first available opportunity to the assessee. The assessing officer has issued the notice under section 133 subsection 6 to the partnership firm, in response to which the partners of the dissolved firm intimated to the learned assessing officer that this firm has been dissolved, now it is not in existence. The notice was sent to the partnership firm for asking various details like business activities, return of income, computation sheet, details of sale and purchase and bank statements, etc. So along with those documents, the assessee has duly informed at the first opportunity to the assessing officer that this firm is not in existence. In spite of that, the learned assessing officer, in spite of issuing the notices to the partners of the partnership firm, continued to proceedings under section 148 with the partnership firm. First of all, the notice was sent to the partnership firm and then the assessment was made under section 147, making some additions. The assessee moved to the CIT appeal. Assessee took the shelter of two very important judgments on this issue, that the assessment cannot be done in the name of a non-existent entity. The cases are Adani Estate Private Limited versus Income Tax Officer. This case has been decided in 2023 and another case is very celebrated judgment of the Honorable Supreme Court, that is Principal Commissioner of Income Tax versus Maruti Suzuki India Limited. The case relates to the year 2019 and the case has been cited at 416 ITR at page number 613. In both these cases, the court has held that the assessment in the name of the non-existent entity is not a valid assessment. The strong point of the assessee was that the assessee has duly informed to the income tax officer that the partnership firm is no more, it has been dissolved, and the assessee has also submitted the copy of the dissolution deed to the assessing officer. The CIT appeal also upheld the order of the assessing officer, so the assessee has moved to the tribunal. Tribunal, after examining all the facts, relied on the cases which have been quoted by the assessee, that is Adani Estate Private Limited and the case of Maruti Suzuki. ITAT said that the facts of the case clearly shows that it was in the intimation of the assessing officer that the firm was no more. So in spite of going ahead with the assessment into the name of the partnership firm, the assessing officer should have proceeded towards the partners of the firm. So in spite of doing that, the assessing officer passed illegal order which is non-est in the eyes of the law, and accordingly the ITAT quashed the assessment under section 147 in the name of a firm which was no more. At the end of this video, once again I am repeating the name of the case. The name of the case is Jainam Exports versus Income Tax Officer, and this case has been reported in 108 ITR Tribunal at page number 1. The matter has been decided by Surat ITAT and the date of the judgment is 26th October 2023. Thank you, friends.